gonna get. Is that okay? You guys, we're good? Oh, you're fine. Okay. All right, good afternoon. Let's try that again, post-lunch. Good afternoon. Thank you very much. So I'm Lenore Palladino. I'm going to be moderating this session. I'm an assistant professor of economics and public policy here at UMass and a member of PERI. And so happy to have this great panel with us today. I'm really, really excited. The panel was not about me, but 30 seconds of my own background. I brought a group of students to Immokalee in 2001, and I was a student labor organizer with Jobs with Justice in the late 90s, early 2000s, and with United Students Against Sweatshops, which led directly to me wanting to be an economist. So I'm very excited to have this conference here at UMass, at PERI, and very excited for this wonderful panel. We're going to do what we did in the morning, which I'll briefly introduce everybody, and then we'll have a series of presentations, and then we'll jump right into Q&A because this is really an expert audience, and I think there's a lot of energy to have good conversation. We are right after lunch, so if you feel yourself getting drowsy, feel free to stand up. We do have a little balcony out there where you can go out and get a shot of sunshine if you need that. I don't know if we have coffee downstairs still, but we should. So please do whatever you need to do to keep yourself awake and animated in this time. Okay, so I'm gonna read out just some brief bios. These are all people with extensive, amazing experience, and so I won't read out everything. You can, of course, find their bios online, but I'll go down the order that we're going to have the presentations, and then we'll launch right in. So Professor Jim Brudney is a professor of law at Fordham University School of Law, and I wish I went there, so I wish he had been my professor, teaching labor law, employment law, international law and human rights, and legislation and regulation. His scholarly writing is in the areas of workplace law and statutory interpretation. Following graduation from law school, he clerked, among other places, for Justice Harry Blackmun at the Supreme Court and served for 6 years as chief counsel and staff director of the U.S. Senate Subcommittee on Labor. He's a co-chair of the Public Review Board for the United Auto Workers Union, which you may have heard about recently a little bit, and is a member of the Committee of Experts at the ILO. Next, we'll have Judge Laura Safer Espinoza. She is the executive director of the Fair Food Standards Council, which we heard some about last night and this morning, which monitors and enforces the Coalition of Immokalee Workers' groundbreaking agreements with growers and retail food buyers to ensure fundamental human rights for agricultural workers. And I'll let her talk more about the program, of course. She's also a former New York State Supreme Court judge who served as a judge and court administrator for 20 years, and she helped design and become the first presiding judge of an innovative alternative to incarceration court for nonviolent offenders. In addition to that, she has extensive history of work with government, human rights, and legal organizations in both the US and in Latin America. Then we'll skip physical location and go next to Lily, who is the co-executive director of Massachusetts Jobs with Justice. Lily is a native of Boston's Chinatown in Quincy, Mass. Her commitment to social justice formed early as a child of immigrant parents and low-wage workers in low-wage restaurant, hotel, and healthcare industries, and she studied at Vassar College and then spent 2 years on the US-Mexico borderland. She was an organizer in 2010 and 2011, leading 2 weeks of vigils. Too loud? Oh, okay. 2 weeks of vigils in front of the Massachusetts State House against proposed anti-immigrant amendments, and then joined Massachusetts Jobs Justice as an organizer in 2012, leading multiple important campaigns for social justice and education in our Commonwealth for the last 11 years now. And then finally, Claudia Quintero is an assistant professor of law at Western New England College of Law, our local law school here in Western Mass, and most recently has led the statewide migrant and seasonal farm worker project as a staff attorney at Central West Justice Center since 2017. Her work has entailed representing farm workers in immigration, wage and hour claims, housing, family and benefits, as well as community outreach and legislative advocacy. So a really incredible panel. And with that, we'll start off with Jim.
Thank you. Can you hear me? Okay, good. Thank you, Lenore, and good program. Okay, thank you. And I want to, in addition to thanking Lenore, I really want to thank Bob and Patrick for inviting me, and Kim and Nicole for their terrific support. My task today as a law professor is to explain and perhaps persuade you that our national labor relations law holds some promise for advancing the well-being and power of low-wage workers. I recognize that law and political economy don't always blend, as Marx, among others, explained, but Bob wanted me to talk about the NLRA, and so warts and all, that's where I'm going, and I'll try to stay and really build on the impressive law-related discussions that happened this morning with Maggie, Jen, and Thea. So the NLRA, as you may know, its protections for labor organizing were enacted in 1935 and revised in 1947. No real statutory changes since then. So I want you to think a little bit about that for a moment. If you would consider other areas of federal regulatory law, like telecommunications or securities law, and imagine if the Federal Communications Act of 1934 or the Securities Exchange Acts of 1933 and 34 had never been amended for 75 years. Workers are living with federal statutory protections that have not been modified by Congress since before Jackie Robinson integrated baseball, since before the birth of the interstate highway system. When it was enacted in 1935, the law was viewed as radical by workers and unions and as a dramatic assault on capitalism by corporations and managers. Now, nearly 90 years later, the statute has not aged terribly well. Gaps and weaknesses have been exposed in the law itself, including exemptions for independent contractors who now oversee a substantial portion of the workforce, and inadequate remedies, especially for intentional statutory violations by employers. The Supreme Court has undermined some basic protections, notably the right to strike and the right of union organizers to solicit and communicate with employees on employer property, some of which we heard about this morning. And workers have to depend on the National Labor Relations Board, the agency charged with initiating enforcement action, which has led to challenging delays as well as politicized resistance when the agency is under the direction of a Republican president. In addition, the act was created to protect workers in an industrial economy at a time when factories employed tens of millions of Americans who were seeking entry into the middle class. It offered protection to employees more broadly, but knowledge economy workers and low-wage workers in retail stores were not its primary intended beneficiaries, and other lower-wage workers in fast food chains or coffee houses or warehouse delivery businesses were virtually non-existent back in 1947. Moreover, two important groups of low-wage workers are excluded from the Act, domestic workers and agricultural workers, and that was, as Maggie explained this morning, regrettably a race-based decision by Congress. So all this may sound like a pretty bleak picture for how low-wage workers can fare under the National Labor Relations Act, but the story has some recent, more promising aspects. And in particular, because all enforcement flows through the agency's general counsel, an aggressive and progressive general counsel can push the statutory envelope. And if she gets support from the 5-member National Labor Relations Board, the result can be meaningfully enhanced protection. And that is what has been occurring since 2021. And I want to take some time to identify several key developments that can promote organizing for low-wage workers. The general counsel in the Biden administration, Jennifer Abruzzo, has expressly formulated a remarkably progressive agenda, revisiting long-standing labor board positions and urging the board to make more pro-organizing, pro-bargaining use of existing statutory text. And within the past year, the board, featuring a majority of 3 Democratic members, Member McFerrin, Prouty, and Wilcox, has responded with some serious reforms to its own positions. None of this directly impacts agricultural workers, nor will it do so unless the act is amended, but it can affect the rights for tens of millions of low-wage workers, roughly 44% of the workforce, service industries, platform economy, and at the same time, I want to recognize Marley Monticello's sobering analysis yesterday about the perils, politics, and pendulum swings. That said, I think it's important to recognize that when the pendulum swings your way, that you might want to take full advantage of it when you have the chance. And to the extent that this builds or parallels some of the gains that Thea talked about in terms of the Biden administration and global work, there is quite a bit that has developed in the last 2 years, even more recently. So in August of this year, the National Labor Relations Board decided a case called Cemex Construction, making it easier for workers to secure union recognition without using the Act's more burdensome and slower election process. Now, when a union requests recognition based on having been designated by a majority as their representative, the employer must either recognize and bargain with the union or promptly seek an election. And in a departure from decades of board law, if the employer commits an unfair labor practice during the election campaign, the board will dismiss the employer's election request and simply order the employer to recognize and bargain immediately. Employers have understood that this is a major disincentive to their committing unfair labor practices during an election campaign. It used to be that those unfair labor practices simply triggered a rerun election. Second recent change has expanded the definition of employees protected under the Act. In June of this year, the board restored a more employee-friendly framework for employment status. The case involved makeup artists and hairstylists at the Atlanta Opera, but the board's decision is especially relevant for gig companies like Uber and Lyft and Deliveroo that rely on contract labor to avoid the costs associated with employing workers, including the cost of negotiating with unions. And briefly, the board rejected the Trump administration's earlier holding that entrepreneurial opportunity for gain or loss should be a decisive factor in determining whether someone is an employer or an independent contractor. Pretty much knocked out Uber and Lyft drivers, others. Instead, the board endorsed the traditional multi-factor common law test, where special attention usually goes to the extent that the owner-manager's controls over the manner in which the work is performed, and also whether, as a matter of economic reality, the individuals are dependent on the business to which they render service. And in a separate but broadly related development just 1 week ago, the board issued a final rule making it easier for multiple companies to be deemed joint employers that share liability for labor law violations and have legal obligation to negotiate with unions. Under the final rule, a corporate entity like, say, Wendy, may be considered a joint employer of their franchisees' employees to share or co-determine the workers' essential terms. Another recent change is expansion of the scope of relief for employees unlawfully discharged during organizing. In December of 2022, the board held that employers committing labor violations during organizing drives must compensate suspended and discharged workers in addition to back pay and other traditional forms of so-called make-whole relief. The decision calls for consequential damages. That is, employers are now on the hook for all direct or foreseeable damages flowing from their violation. That includes out-of-pocket medical expenses, credit card debt, missed mortgage and rental payments, and that decision substantially raises the cost to employers of violating workers' rights during organizing campaigns. Previously, the main remedy was simply restoring the back pay that had been lost when you'd been. Let me also highlight two initiatives by the General Counsel that remain to be addressed by the board. When the General Counsel issues memos to the agency's regional offices around the country, she's signaling what will be her prosecutorial position going forward, and effectively inviting those offices, and there are 26 of them, to find her suitable cases before the full NLRB, to take before the full NLRB. So in a General Counsel memo in May of this year challenged non-compete agreements as interfering with employees' rights to organize. And the GC took the position that maintenance and enforcement of these non-compete agreements or provisions in employment contracts, if you will, and also in severance agreements, violate the NLRA except in very limited circumstances. He explained that these overbroad non-compete agreements are unlawful because they chill employees from exercising their rights to collective action to improve their working conditions by taking various steps, such as concertedly resigning or improved working conditions, or soliciting their coworkers to go work for a local competitor as part of a broader course of protected concerted activity. A second GC memo issued in April of last year insists that employees have the right to refrain from captive audience and other mandatory meetings at which union organizing is discussed. The captive audience meeting, one of the oldest, most heavily used employer tactics during an organizing, is what it sounds like. The employer announces there will be a mandatory meeting on the clock at which union organizing drive will be discussed. The employer will speak, not the union or its supporters. Employees are paid to attend. They can be disciplined or fired. They do not because it's part of the regular workday. The GC announced that the board decision, which dates from the 1950s, permitting such meetings should no longer apply. As is true with respect to non-compete agreements, she is looking for the right case from one of the 26 regions to bring before the full board, arguing for its use. So these and other changes in labor relations law during the organizing stages of a union campaign will make it easier, are making it easier for low-wage workers to organize. And once they do organize, the logical next step is to negotiate and secure a collective bargaining agreement. Major unions in established industries often can get a new contract through bargaining, times augmented by strikes. Obviously, the UAW is a recent successful example of that, as is the Writers Guild, Kaiser Healthcare. They can also pressure employers through high-visibility consumer campaigns or related public pressure. But when you're talking about unions with hundreds of small employee units, they have struggled much more in the face of scorched earth employer tactics. CIW obviously has blazed a path in this regard for agricultural workers outside the scope of the NLRA, but consumer boycott campaigns can take a long time. The Starbucks saga makes clear how one particular aspect of our labor laws continues to pose serious obstacles to the ultimate goal of the union organizing effort, securing a collective bargaining agreement. Despite the fact that Starbucks workers have voted in favor of union representation in more than 280 stores in January of 2021, not a single collective bargaining agreement has been bargained. Instead, Starbucks has fired nearly 200 union activists and supporters, continues to threaten reprisal against its workers around the country if they vote in favor of unions. The NLRB regional offices have brought 100 separate cases against the company, alleging more than 1,000 unlawful actions. But even when many of these alleged violations are established, the remedies available under U.S. labor law are simply inadequate. Crucially, when Starbucks is found to have bargained in bad faith, the only law-based relief is an order to return to the table and bargain. The Supreme Court held in 1970 a case called H.K. Porter that while the NLRB has power under the Act to require employers and employees to negotiate, it does not have the power to compel either side to agree to any specific substantive contractual provision of a collective bargaining agreement. That was not the only way to understand the text of the Act. Section 8D, I'm sorry to get into the weeds here, but Section 8D of the Act says that the obligation to bargain does not compel either party to agree to a proposal. But Section 10C, which covers relief act, says that the board, opposed to the parties, may take such affirmative action as will effectuate the policy of the Act. But short of revisiting the Supreme Court's decision, what, if anything, can be done about this? Well, General Counsel Abruzzo has a plan here. He is looking for a suitable case in which to argue that the Labor Board retains the power to impose serious monetary penalties on employers and remedies for workers in exactly those terms when the employer's refusal to reach an agreement to revisit its 1970 case, when the employer's refusal to reach an agreement is in bad faith. And that kind of relief is going to require the board to revisit an infamous 1970 decision called Excello. And the board there concluded, now I'm really getting into the weeds, but I hope you'll follow me. The board there concluded that a so-called compensatory bargaining was both unlawful under Supreme Court precedent and inappropriate Relations Act. But in fact, as General Counsel wants to argue, such an order is both lawful and also appropriate in the right circumstance. So let me try to explain that for a couple of minutes. The Supreme Court in 1970, in H.K. Porter, disallowed compelling terms of a collective bargaining agreement as unlawful because that would have controlled future relationship of the parties for the length of the collective bargaining agreement, say 2 years or 3 years, 5 years. But a compensatory bargaining is different. It's a make-whole remedy. Compensates employees for what they would have lost economically in the past by virtue of the employer's bad faith. In Starbucks, for instance, the workers and their union would propose as remedial terms what they believed they would have received in wages and benefits had the employer bargained in good faith agreement. And the board can make that award for the period of bad faith, say 12 months, 24 months, 36 months. But Starbucks is under no obligation going forward to accept those terms in a new collective bargaining agreement. It just has to pay for what it has done in the past. The other issue in Excello is whether a compensatory bargaining order is inappropriate because it is simply too speculative to be sustained. The argument is it's a so-called agreement in the air. Now, there is, of course, a minimum basis for such a remedy, which is the wages Starbucks itself had been paying when it started bargaining in bad faith. But as for how much more Starbucks might have agreed to, there are benchmarks out there that are available even though Starbucks can't enter into any agreement. One benchmark would be the wages and benefits paid to workers with CBAs in other cafes or coffee houses across the country. Hundreds of these workers have organized from Seattle to Boston, and there are union contracts at a number of these places. Another benchmark would be Labor Department data on the percentage of changes in hourly earnings, both wages and benefits, the period of bad faith. Again, 12 months, 24 months, 36 months. Think about how much hourly wages have risen in the U.S. workforce since the pandemic, labor shortage. I'm not saying these are easy judgments to make, simply that they're far from impossible to speculate. And courts often, by analogy, offer front pay to victims of discrimination as remedies, dating from the point they were discriminated against to the point when the victim is expected to find equivalent employment. The court is doing that speculatively when the employee is going to get another job. Finally, a productive area of organizing for low-wage workers in the public sector is state universities. They employ tens of thousands of graduate students working as instructors, researchers, and TAs. And here I just want to touch on a dramatic recent success, which is UAW Local 2685, which represents 36,000 knowledge workers at the University of California. The local secured and the members ratified new contracts that provided the largest ever increases for any unionized higher ed workers. In addition to those wage increases, which range from 25 to 80%, they provided for substantial increases in child care subsidies, dependent health care support, fully paid parental and disability leave, protection for employment related to work authorization and other immigration focused issues. Obviously, organizing at public universities is regulated by state law, not federal law, so the state story will be different in Texas or Alabama than it is in California or, I assume, Massachusetts. But the recognition of university RAs and TAs as low-wage workers is very important and is a welcome development.
Well, adjust the mic. Good afternoon, everybody, and thanks again to the fantastic organizational job done by PERI, and particularly Professors Pollan and Patrick Mason, our longtime Fair Food Standards Council board member. When you first started talking to us about this conference, I don't think I really imagined a room full of amazing people that are gathered here and that we got a chance to speak to last night as well. We'll see if you feel the same way after now having to listen to a judge right after a law professor. So we'll see. But one of the many interesting things that Professor Mason, Patrick, said in his presentation last night was that most economic courses do not teach students about the power dynamics in society. Those listening to this conference are hearing a lot about precisely that. And as you've already heard from my colleagues, the Fair Food Program is nothing if not a story about power relationships. In fact, in the late 1990s, the area of Southwest Florida that gave birth to the Fair Food Program was known to federal prosecutors, not labor activists, but federal prosecutors, as ground zero for modern-day slavery. And I would not be here about to describe the monitoring and enforcement mechanisms of the very first worker-driven social responsibility program if workers at the bottom of the food supply chain had not harnessed tremendously effective market power in order to dramatically change the power relationship in their workplace. The students of history among you will recognize that in doing so, the CIW has broken a continuous thread of exploitation and forced labor in U.S. agriculture, particularly Southern agriculture, that has existed since the days of chattel slavery. The tools of post-emancipation abuse create vulnerability for debt, peonage, and forced labor are really multiple and have been called out by a lot of my fellow presenters, so I'm not going to go into them now, but I do want to, all of the exclusions that left people vulnerable to debt, peonage, forced labor, but I do want to call out one abysmal failure to enforce the protections that do exist. And so, we'll see. Although the State Department has credited CIW's work as the spark that ignited today's national anti-human trafficking movement, and their participation in investigations and prosecutions has and continues to free thousands of workers from forced labor, those remarkable efforts are actually not the most transformative change that their movement has brought about. As workers, the goal was not to win presidential medals for combating human trafficking, although that turned out to be one result of their efforts, and you can see that here. But rather, it was to prevent suffering from happening in the first place. So we, in our work at FFSC, are privileged to witness how that plays out on a daily basis. But it's also important to understand that outside the program, farm labor exploitation is a very big business, and it's only getting bigger with the explosion of the guest worker program over the past several years. In a case that should have been a huge wake-up call for the food industry and consumers, right before Thanksgiving of 2021, the Department of Justice announced a huge forced labor indictment in southern Georgia, the result of an investigation by Homeland Security and many other federal agencies. The indictment is a 50-page tale of horror, exposing a massive operation that had exploited and abused thousands of guest workers over a 5-year period, including selling workers to employers for cash, holding them behind electrified fences, violence including sexual assault, and working conditions so horrendous that at least 2 workers died as a result. $200 million was illegally obtained from this human misery, and attorneys working in the area have stated that this case is only the tip of a very ugly iceberg. Just 2 months earlier, in September of 2021, another indictment was brought by federal prosecutors in Florida against a multi-state forced labor operation run by labor contractors who were victimizing guest workers in Florida, Kentucky, Indiana, Georgia, and North Carolina. At the same time, as you heard earlier, there is a tool, a withhold release order, that has been employed by the Biden administration to block produce coming from certain Mexican operations where egregious cases of forced labor have been uncovered, and otherwise that produce would also be flooding our supermarkets. As many of you also know, there now exists a multiplicity of corporate social responsibility programs, multi-stakeholder initiatives, even apps, right, that purport to minimize supply chain risk. So why is it that after 3 decades of such programs, stunning cases of abuse continue to surface, many of them in CSR-certified operations? A growing volume of in-depth studies have found that over the past 30 years, corporate social responsibility programs and MSIs that were created primarily to deal with public relations crisis, as others have said, do not center workers in their structures or function, and lack meaningful or any monitoring and enforcement mechanisms, has dismally failed to protect the most vulnerable workers in our supply chains. In fact, it's well documented that the most egregious abuses of forced labor, child labor, and retaliation continue unabated on their watch. At the same time, consumer organizations are increasingly outraged and seeking accountability for both companies and certification schemes that make empty promises about human rights in supply chains, including bringing lawsuits for false and deceptive marketing representation. So what is so very different about the worker-driven social responsibility model that enables it to eliminate and prevent the egregious levels of abuse that are otherwise so entrenched in U.S. agriculture and many other supply chains? The answer really lies with the fact that workers who had suffered everything I've been describing and what you heard from Lupe and Greg this morning were able to recognize the opportunity in that same market power of consolidated retail buyers that was causing misery at the bottom of the supply chain. By winning agreements directly with those brands for the very first time in history, farm workers reversed some of that forceful market downward pressure, gained ongoing control over their employers' ability to sell their products to consumers. I'm going to say that again. Ongoing control over their employers' ability to sell their products to consumers and the ability to build their own program. In those legally binding agreements, now 14 retail brands, supermarkets, food services, fast food chains, commit to purchasing from growers who are certified by the Fair Food Program to be respecting workers' human rights, and to pay a small premium for their produce that workers receive as a bonus in their paycheck. Equally important, they agreed to cut off purchases from any grower that is suspended from the program. Those powerful market incentives have brought dozens of growers across 10 states and multiple crops into the program, where they commit to a human rights-based code of conduct and to cooperation with Fair Food Program monitoring. The code also provides for a series of unique implementation mechanisms designed not by corporations or, with all due respect, academics, but rather by workers who understood what it would actually take in their workplaces to root out abuse. As a result, standards are based on workers' experiences and priorities. Follow the law is a baseline, and to highlight just a few of the many important ones that may go beyond that low bar, the code requires direct hire, which has eliminated much of the power of farm labor contractors, the usual perpetrators of forced labor, and made growers directly responsible for their workplaces. A mandatory clean channel for recruitment when guest workers are used, and true zero-tolerance provisions for forced labor, child labor, violence, and sexual assault. Beyond this, there are requirements for continuous worker education and multiple complaint mechanisms that must operate free of intimidation, coaching, or retaliation. Also of critical importance are requirements that have eliminated sources of systemic wage theft and supplemented workers' income to combat the kind of insecurity that, together with threats of retaliation, had always ensured silence in the face of abuse. Additionally, there are work environment requirements dealing with discrimination, sexual harassment, and verbal abuse, as well as workplace safety, including protections against dangerous conditions, including unsafe transportation, exposure to lightning, pests, and pesticides. Important to understand, the code is not static, but continues to evolve based on feedback received from workers. That has included the implementation of new field truck safety protocols, and most recently, to deal with rising temperatures and heat index with the adoption of mandatory heat stress prevention protocols. The program also requires worker education on those standards that is as deep and wide as possible. At the point of hire, before setting foot in the fields, each worker receives the coalition's booklet and views a video on their rights, scripted and acted by farm workers themselves. Additionally, during each harvest cycle, CIW's Education Committee, as you saw in the video that Greg showed, carries out interactive worker-to-worker education using popular education methods both to convey information and to elicit workers' concerns. And through that intensive education process, which, by the way, takes place on company property, on company time, so workers are paid for it, it's created tens of thousands of worker monitors who are prepared to exercise their own rights every day in workplace interactions and in worker health and safety committees, as well as in their interactions with the program's formal monitoring mechanism. And someone asked last night about that mechanism. That is done by the Fair Food Standards Council, a separate nonprofit organization solely dedicated to the purpose of monitoring and enforcing CIW's agreements with participating buyers and growers. At least once a season, all participating growers are audited in announced and unannounced audit with unprecedented access, and this is even more important in light of the recent Supreme Court decisions that were cited, to workers in the fields and at company housing outside the presence of supervisors. All levels of management and at least 50% of the workforce at any given location are interviewed. We also perform comprehensive reviews of grower records, including payroll, and monitor premium payments to workers. Then, detailed reports and corrective action plans are generated and tailored to each operation. It's the opposite of a cookie-cutter approach. If urgent noncompliances are found, farms are put on probation, and auditors can then return as often as necessary to ensure compliance or to make findings supporting suspension. However, as everybody here knows, the very best audit is really only just a snapshot of conditions at a moment in time. So even more critical to program monitoring is the live video feed that is provided by our 24/7 complaint mechanism. That complaint hotline is answered by the same multilingual investigators who conduct the audits and are therefore familiar with the situations that workers are calling about. Expedited alternative dispute resolution procedures that incorporate elements of both traditional as well as restorative justice are used to resolve complaints. But as the program's monitor, The council has the final say on both findings of fact and corrective action. Right, Jim? So, appeals can be taken by growers only through the code's expedited arbitration proceedings. In the beginning, it was necessary for workers to witness prompt, effective resolutions before the fear of retaliation could be overcome. Some of those included public apologies by company owners themselves and supervisors, in addition to other corrective actions. A truly dramatic and emotionally impacting reversal of power dynamics. At least 50% of all complaints resolved since implementation in 2011 have been resolved in under 2 weeks, and 80% within 1 month. And that's critical because for migrant and seasonal workers, justice delayed is truly justice denied. Finally, and also just out of my former life, and anybody who's litigated or anybody who's been before an agency, you know that that is lightning speed. So finally, and most importantly, enforcement is backed by prompt and effective market consequences. Suspended growers simply can't sell their produce to participating buyers, and therefore, as you can imagine, they are highly motivated to comply. If you remember nothing else from everything I've said, please remember that human rights standards without meaningful monitoring and enforcement are simply worth zero, and pretending otherwise is both false and also harmful. Workers have continued to participate actively in the Fair Food Program's mechanism precisely because they have seen the worst practices and actors weeded out through their own input into education sessions, audit corrective actions, and complaint resolutions, resulting in vast improvements in their work environment, as well as over $44 million in premium distributed in their paychecks. The program has really made the right moral choice for employers, also the right economic choice. So when faced with, for example, firing a sexual predator or retaining a supervisor who they feel gets amazing production out of workers, weighing that against losing sales to participating buyers, they've always managed to make the right moral decision. Buyers have achieved transparency and risk prevention, so instead of waking up to headlines of shocking abuse in their supply chains, they've seen supplying farms described as the best work environment in the U.S. agriculture on the front page of the Times. And growers have become employers of choice with less turnover. That's their own term. We didn't think of that. Safer workplaces, meaning an end to the cycle of forced labor cases and judgments against them, as well as receiving the purchasing preference and a wage supplement that costs them nothing for their workers. The program's success has fueled expansion in buyer supply chains to 10 states and multiple crops, and now internationally in a pilot supported by iLab. Thank you very much, iLab. We are so excited to be working with you. As government agencies, the State Department, DOJ, Department of Labor, even Customs and Border Protection, not necessarily a national ally for us, and including most recently the USDA, provide recognition of the program's achievements and incentives to growers who participate. Many more growers are seeking to join. That is a map that shows the current state of the Fair Food Program, the free territory, as we like to call it. So last but not least, the worker, as you heard from Thea this morning, the Fair Food Program's worker-driven social responsibility model has also inspired workers in other supply chains around the world on both the domestic and international fronts, ranging from dairy in the US and the Milk with Dignity program, to construction in the Twin Cities area, to garment industries in Bangladesh, Pakistan, Lesotho, where millions of workers are using the power of worker-driven social responsibility to address issues of factory safety and gender-based violence in the workplace. Programs in the UK fishing and the Chilean salmon industries are on the runway as we speak. The common factor that is necessary for all of these efforts to sustain and grow is the action of conscious consumers, who, whether we are buying solely for our own families or for institutions and companies, large and small, we all have critically important choices to make.
Hello. Hi, my name is Claudia, Quintero, and I am an assistant professor of law at Western New England School of Law and also staff attorney at Central West Justice Center, which is a legal aid organization here in Western Mass. What I'm going to do today is I'm going to talk a little bit about my work with Central West Justice Center. I'm going to talk a little bit about what we do there in regard to representing farm workers. And then I'm going to talk a little bit about a legislative effort that we have undertaken in response to some of these inequities that both of my colleagues here have expressed. I do want to thank the organizers for the PERI conference for inviting us to speak. I especially want to thank Dr. Wixlim for the support she has provided as part of PERI in the efforts that we've undertaken on behalf of farm workers in Massachusetts. So at Central West Justice Center, which is a legal services organization in Springfield, we are part of an affiliate that maybe some of you are aware of named Community Legal Aid. We're a legal services organization in Western and Central Massachusetts where we provide legal services to low-income people in the region. Our services cover from Worcester all the way to the New York Berkshires line, and then from New Hampshire all the way down to Connecticut. So we have pretty broad representation. But we also house the Migrant and Seasonal Farm Worker Project, which is the only statewide project directed to providing legal advocacy to farm workers in Massachusetts. There are others in New England. There's Pine Tree Legal Services up in Maine, and there's Connecticut Statewide Legal Services in Connecticut, which do a little bit of what we do. But what's unique about our project is that we are not limited by our funding. We receive only state funding, so we can provide more direct advocacy to undocumented workers living and working on farms, in addition to H-2A workers, which is a small number of the farm workers that we represent. So in that work, we provide civil legal direct advocacy. And when I say we, I mean myself and my colleague, Maya McCann, who's back there. And I'll talk a little bit about what she does at Central West. But what we do is we provide direct legal services in the areas of immigration, housing, wage and hour claims, benefits, family law, education, and anything that comes up from a farm worker. So sometimes they need R&B services, sometimes they need different civil legal matters. And if we can't help them, we refer them to private counsel or other agencies. The other thing that we do is we do farm outreach. So we go out and we visit farms across Massachusetts to kind of just, audit a little. And we do have the backing of a lot of state agencies that work with us. We work closely with the Attorney General's office. We work closely with the Department of Labor, the State Monitor's office. So we work, and with OSHA, in that regard to sort of, if we see something, we say something. But we go out and visit farms across Massachusetts, get to talk to workers, get a sense of where are the workers located, because if they're located in extreme rural areas where they can't even access healthcare or other services, food, we want to know that, is it going to be hard for them to access our services? How far are they from our offices? We do have offices in Springfield, Worcester, Northampton, Pittsfield, and then we have some satellite offices in Fitchburg across the state. So when we go out and we do outreach, primarily during the agricultural season, tends to be April and November in our state, we go out and we visit some of the housing. We see if there are facilities, restrooms, access to water, things like that. And we just try to get to know the workers, tell them who we are. When the new case that came out last year kind of limited our ability to go out to do outreach on the farms, but we try to do the best we can. We work a lot with partner organizations that provide other services, education, healthcare, to try to piggyback on them and kind of show up, hey, we're here. The other thing that we do is we do Know Your Rights trainings. We partner a lot with organizations across the state, and we go out and we do Know Your Rights trainings on what are your rights as a worker, what are your rights as a tenant, what are your rights as an immigrant, and we make sure that the workers have access to ask us questions specifically about their concerns. So we just did a couple out in the Berkshires. We've done a few out in Eastern Mass. Oh, I forgot to say this, but the cool part about our project is that we're a statewide project. So we go out all as far as New Bedford, the North Shore, and of course out in the Berkshires and up and down the Connecticut River Valley. So we're pretty busy. And then in addition to what we've been doing, lately we've been engaged in legislative advocacy. And so I pulled up our website, the Fairness for Farm Workers Coalition in Massachusetts. At Central West, we also lead the Fairness for Farm Workers Coalition. And what's really neat is that we have a lot of partner organizations who are part of this coalition, including folks from Eastern Mass and folks all around the state. But what's important is that we also have workers be part of the coalition, because we can't do this effort without the grassroots organizing and the grassroots work that workers are engaged in. And so we work closely with the Pioneer Valley Worker Center in Northampton to include the farm worker voice. And then we've also tapped into other farm workers that are not related with the Worker Center, but are across the state, representative of different industries. So for the past 3 years, we've been engaged in legislative advocacy. We started with drafting a bill in 2020, which was like just really bad timing because we drafted our bill, we were in negotiations, and then COVID happened, and that sort of put a stop to that. But our bill was in direct response to the fact that farm workers in Massachusetts still can legally make $8 an hour. And that's part of the exclusion from the Fair Labor Standards Act, and of course the exclusions that my colleague Jim here talked about in regard to the exclusions for the National Labor Relations Act. And so in part of our work, we had engaged in some impact litigation where we argued, and we talk about, our website has a lot of resources about some of the stuff that we've been doing for the last few years. But one of the things that was an impetus for this was we filed litigation in around 2015, 2016 against a grower here in Whately. And this grower was not paying workers for hours of overtime, where they had been working 60, 70 hours at this facility. And so the argument was actually quite nuanced. We said that these workers were in fact not farm workers because they were not engaged in farm work under our wage laws. The definition of farm work is planting, harvesting, and growing. And we said, well, these workers aren't planting, harvesting, and growing. They're doing secondary agriculture, which we know that some states, and in fact, the federal law recognizes secondary agriculture, cutting, washing, sorting, cleaning, etc., does qualify for farm work, but we were trying to be smart. And so we said, these workers are not engaged in farm work. In fact, they're just like any other worker, and for that reason, they should be paid overtime. Well, that case went up to the SJC. The SJC took it on appellate review, a case of first impression, and agreed with our position that, in fact, these workers were not farm workers and were not engaged in farm work, and then took it one step further to a little bit to our horror. We're like, and in Massachusetts, farm work is planting, harvesting, and growing. So any worker that's not planting, harvesting, or growing is not a farm worker, and therefore should be making minimum wage and should be earning overtime. Well, you can imagine what that did for the agricultural industry in Massachusetts, where farmers were extremely confused as to, what am I supposed to do now? If a farm worker picks a strawberry from the ground, they wash it, they take the stem off, they cut it, and they put it in a box, how am I supposed to separate that work between, now I'm paying you $8 for doing that, and I have to pay you $15 for doing everything else? How am I supposed to separate that? So in response to that, we said, well, clearly we have a problem here. The problem is not your problem. The problem is that we are still paying farm workers $8 an hour, when in fact, let's fix this problem and let's just pay the worker $15 for picking the strawberry, plucking the stem, cutting it, washing it, boxing it. And then your problem is resolved. So, seemed easy to us, but not everybody agreed with that position. We had many hearings after that, many with the State Department of Labor Standards, who issued guidance on our decision, on our SJC decision, arguing that, okay, well, if you're going to be paying overtime on this work, you are going to have to pay overtime not on 40 hours of farm work done on a farm, of secondary agriculture done on a farm. You're going to have to pay 40 hours only on the secondary agriculture done on a farm. So for instance, if you have a worker who's working 35 hours on a farm, but they're doing planting, harvesting, and growing, and then they're doing 10 hours of secondary agriculture, no overtime, because they're working 45 hours, no overtime. They have to work 40 hours of secondary agriculture, washing, sorting, boxing, etc., in addition to the 35 hours that they're working doing planting, growing, and harvesting. So they have to work essentially 75 hours to be eligible for any actually 76 hours in order to be eligible for any overtime, which our position was, well, that's not really what the SJC said. That was the ruling or the way that we apply this law. But if you wanted to do that, go for it. We didn't really agree with that interpretation. So we decided, okay, here's the bigger problem. The bigger problem is that we have inequity amongst our workers in Massachusetts, which is, as we've heard throughout the conference, a result of a racist legacy, and we need to fix this. And so in 2020, we drafted and we filed legislation that would allow farm workers to earn the state minimum wage of $15 an hour, to earn overtime for seasonal workers at 55, and for year-round workers at 40, and then to have a day of rest. What we heard was that because of Massachusetts climate, because of the way that Massachusetts operates, it's impractical to have overtime at 40 for seasonal workers. And that what would happen is that it would be actually harmful to workers to implement like such a short threshold, because they would then lose hours of work because they would be capped at 40. So we had a conversation with many of our worker committee members, many of the farm workers who felt like for them it was important to be able to have access to these hours, because many of our workers in Massachusetts, we have about 13,000 workers, 7,000 farms. Only about a third of the farms hire farm workers. And of these 13,000, about 2/3 are domestic workers who live and work in Massachusetts. So we have a small number that come on the H-2A visas, but those workers are not entirely affected in the way that we're talking about the domestic workforce. So our domestic workforce voted that they wanted the 55-hour threshold so that they would at least be guaranteed 55 hours of work during the season, and then any triggered overtime would be probably smaller than if they were working, the overtime was triggered at 40. We had conversations with farmers, we had conversations with many stakeholders. Our bill went before the Joint Labor on Workforce Development last session. We had a hearing, and we had a lot of testimony from a lot of different people. We had testimony from national organizations. We had testimony from different sectors in Massachusetts, including health advocates, education advocates, saying that this is really important for a number of reasons. One, social determinants of health tell us that good wages allow people to have housing access, good food, healthcare, etc. So unfortunately, our bill didn't make it out of the committee. So we continued with our research, we continued with our studying, and what we discovered is that the information available about farm workers is very bifurcated, and it's spread out all over the place. And so we decided to publish a white paper, which you can find on our website, about the status of farm workers in Massachusetts. Who are they? What do we grow in Massachusetts? Many times we met with committee members of the legislature who didn't even know we had farm workers in Massachusetts. What? We grow lettuce? Yeah, who would have thought? We have so much produce that we grow in Massachusetts. We have, I mean, if you drive down Route 9, you see all that produce. And in Hadley and this general area, there's a large number of farms. So we know that there's farms here, but the folks in the eastern part of Massachusetts don't. Massachusetts is one of the top 5 producers of cranberries in our state, in our country. obviously we're coming to a point where many of us are going to be ingesting and eating cranberries, whether in a can or from scratch. But Massachusetts and the workers therein are the ones helping cultivate that. Massachusetts is also one of the top 3 states that sells direct to consumers in our state. So many of the workers are producing and harvesting produce that we as consumers are directly buying. So they're not selling to wholesalers. Some are, but we're a big state that sells directly in farmers markets, places where we're directly consuming what's being grown and harvested locally. So we also worked with the UMass PERI Institute on developing a report, which Professor Wixlim helped with, on what would it cost to pay overtime for farmers. And this analysis, because we know that the economics of it is a really important question, was really fruitful in helping us thinking about how do we leverage the cost of, is that what I sound like? how do we leverage the cost of overtime in our state and in our country? And so we actually now have refiled our legislation with one small change, well, one large change, adding a tax credit to farmers to help offset the cost of overtime. We know that our friends in Oregon are already doing this, and we had many conversations with advocates in Oregon. How did you get it done? What was the impetus? How can we do this in Massachusetts? And we know that our friends in New York are doing something similar. So following in their lead, we're proposing ideas and we're strategizing and we're problem solving on how can we make this feasible for our state. And so we've also done analysis. How much would this cost our state to offer a tax credit, at least a temporary one that would allow farmers to not feel the pain of paying this overtime. I mean, we know that our farmers are struggling with the floods that happened in Western Massachusetts, but we just had our legislative hearing last week, and we mentioned that though the state offered a $20 million appropriation to farmers for their losses of the crops, none of that money ever went to farm workers. And in conversations with legislators, they did note that administration made a failure to make sure that some of this money was directed directly to farm workers. Instead, it was like, here you go, have some money, sorry you lost your crops. But the farm workers ended up losing jobs and hours. So now as they're going into the off season, many are going to be struggling with housing insecurity, food insecurity, etc. And we shouldn't let that happen in our state. So part of what we're doing is thinking about how we can keep our campaign going. We have a public campaign where we're trying to raise awareness to get people to support this cause. But we're also working on having people bring their expertise to help us on multiple angles and multiple ends fight this. Because if we have union organizing, if we have legislation, if we have litigation, we can on all fronts help do this. So this is what we're doing at Central West Justice Center. We keep very busy. I do invite you to check out our website. You can sign up to stay in the know. And there's a lot of information. We have a fact sheet. We have our bill up there. We have some press. And part of it is we understand the concerns that farmers have. We understand the tight pinch, but that shouldn't be on the backs of our farm workers, given how much they already deal with. So if we can, as a state, remedy that wrong, we're going to be all right as a state, but we have a long way to go. So thank you.
Thank you. So good afternoon, everyone. Thank you to all the speakers before me, and thank you to all the organizers of the conference. So my name is Lily, and I look forward to spending time with you today. I wanted to start off with a little bit about myself, to tell you where I come from and why I'm so committed and honored to do this work. Here's a photo of me and my cousin praying to our ancestors for good grades. And then next is a photo of myself with my Aunt 2, who was a grocery worker in Chinatown for many decades, and my Aunt 4, a PCA for many years. And finally, here's a photo of me at the 2019 May Day rally in Boston. And so, like Lenore said in my introduction, coming from a community with children and families just like mine, and seeing my family work in low-wage jobs, from restaurant to hotel to textile factories, I saw firsthand the importance of advocates and organizers like all of us in bettering our jobs and our lives as a whole. And at one point in my organizing career, I witnessed my dad go through very severe mental health and physical health struggles, never having taken a day of vacation or sick time in his life, while at the same time witnessing many undocumented students and immigrant students tell their story and step into their power. And when I saw that dichotomy in front of me, I realized that when we speak out and when we organize, we have the possibility to win. We don't always win, which is okay, but we have the possibility to win. And that's when I made my own commitment to always organize and always advocate for low-wage workers, just like the family I grew up with. So a little bit about Massachusetts Jobs of Justice. We are the leading statewide workers' rights organization and coalition in Massachusetts advancing economic justice, reproductive justice, and racial justice. We were founded in 1985, and we have offices in Boston and Springfield. And we're an affiliate of a national network of jobs of justices across the country. Some of our recent victories include the very first week of the pandemic, and for a couple of months and years onward, raising more than $1.5 million. That was with our staff of 4 people, and dispersing all that money right back into the hands of undocumented workers via Mass UndocuFund to in every county of Massachusetts, winning more than 1.4, the weird number, billion for public education in Massachusetts through the Fund Our Future campaign, and updating a decades-old funding formula that really disenfranchised communities with more students of color, low-income students, and students with special needs. And winning paid family medical leave on the ballot for Massachusetts families. So today, I'm going to talk about how we do it at Massachusetts Jobs of Justice, how we are defending and expanding workers' rights in the context of the workplace, and also what we call all of our sites of struggle. All workers have rights in their sites of struggle, whether that be the workplace, the home, the school, or in the community. And we know that when a person builds and feels power at one site of struggle, that bravery, that voice, and that leadership translates to all realms of their lives. So one story is when our friend Janet, a daycare worker, was facing deportation in Boston. She and her family and friends found courage to organize a grassroots campaign to stop her deportation. Janet and her family circulated a petition, spoke at churches and other places of faith, galvanized her daycare workplace and her children's school communities. And after Janet won and stopped her deportation, she took all of that organizing energy and her leadership to fight for justice in other realms of her life. She and the other families at her children's school campaigned to stop the takeover of her bilingual public school. And she campaigned with her family to ensure that her sister, who was undocumented at the time, received the necessary medical care for a kidney transplant. So every day, we see that when we do build power among workers at one site of struggle, we see their power multiply and spread through the realms of all of their lives and in our community. So the question is, how do we do it at Jobs of Justice, right? And for all the organizers and advocates out there, this is nothing really new, right? This is the secret sauce. We at Jobs of Justice are historically a coalition, so we believe that we are building a powerful coalition that supports powerful organizations and a powerful base building in a landscape of a powerful movement. So for Jobs of Justice, our North Star is coalition building. And we aren't a worker center or a legal advocacy center, but we do have longstanding relationships with nonprofit organizations, community-based building organizations, immigrant organizations, and worker centers across the state. And when our movement partners and coalitions are strong, our coalition itself is strong. Then it's campaigning, running strategic campaigns that target bad bosses and bad actors that bring people into the movement. Campaigns are just the vehicle, right, that we use to utilize to outreach to people in the streets, at the doors, in the schools, at the workplace. And that's how we bring more people into the movement and into our organizations. Organizing, facilitating outreach and deep relationship building that focuses on leadership development. Organizing is slow and takes years and years, while mobilizing, especially over social media, right, takes moments. But we know that our power is in our people, and we understand that our relationships are going to take time. And the leaders that we build today are the ones that we're going to build for the years to come. And then communicating, crafting a meta-narrative that highlights our intersectional struggles and shows the rest of the world what is possible. Every day and in every campaign, in every project that we do at Jobs with Justice, we are going through this spectrum, right, this flow of organizing, base building, communicating what we're doing, and building our coalition. So today, I wanted to share one story about how we utilize that flow in a really important campaign that we did. So in 2017, think back to 2017, during the many flashpoints of Trump's anti-immigration policies and sentiment, many immigrants who had been receiving stays of deportation or prosecutorial discretion for decades were suddenly receiving orders to leave the country immediately. Francisco, a custodial worker at MIT and a member of SEIU 32BJ, was one of these immigrants. Though he had applied for asylum in 2007 and was denied in 2011, he had been receiving prosecutorial discretion since 2011. He had 2 daughters in the country, a 10-year-old and a 5-year-old, and a baby on the way. But the day he went back to get his usual prosecutorial discretion, he received his order to leave the country immediately. So what did we do when we heard this? First, we brought everyone to the table. Francisco, his mother who worked at a produce factory. We notified his union and brought them to the coalition table. And soon we not only had his union, but Chelsea Collaborative, a local grassroots organization, his church, local elected officials, and also student organizations from MIT. Everyone played a role in his campaign, whether it was collecting signatures on the MIT campus, hosting rallies on the MIT campus, to organizing musical protests in front of the detention center in Boston. Francisco received an immense amount of local and national coverage, more than I had ever seen in my years of organizing. And we were able to take this moment in time and ensure that we had enough support that we could and were able to change the narrative about workers' rights to remain in the country. This pressure also moved MIT to support and provide many resources to our campaign, like their general counsel to work with the union's lawyers and Francisco's private lawyer on the campaign to stay in the country. As in this campaign, in every campaign, we test and explore, and we also try to grow new leaders. So during the campaign in the middle of the year, we had expected, and it did unfortunately happen, that Francisco was taken in custody and placed in the Suffolk Detention Center. During that time, we had seen in visitor guidelines, when I brought the family to visit Francisco in the detention center, that unlike general visitors like you and me, who had to go through, and their family, right, had to go through a really onerous verification process where they go in, they apply, they wait at home for 2 weeks until they get approved, and then they can finally go in during the visiting hours. Clergy could almost walk in and out of the detention center, visiting whoever requested to see them. So first, we tried with Francisco, and we invited a local rabbi and a local UU church leader to visit him, and they got in. And so Francisco was able to share this information and this tactic to bring more visitors from the outside in and witness what was happening at the detention center and build campaigns outside to support the people detained inside. He was able to share with his friends and his friends in the detention center, started inviting other faith leaders in our network to visit them in detention center. And soon, we were able to expand this resource of faith leaders visiting people in detention, as well as everyday volunteers like you and me, to write letters to people inside the detention center and to have this two-way communication where before that people felt very isolated in the detention center. So after more than a year of campaigning, visiting Francisco in detention, standing outside with rallies and vigils, and going to court, we were able to win a stop to Francisco's deportation. With a robust coalition, strategic campaigning, leadership development of faith leaders and community activists, as well as Francisco's daughters, we were able to imbue so much meaning that Francisco belonged in Chelsea, that Francisco belonged at MIT, and in the U.S., that we were able to show as a test, right, to the then Trump administration, that everyone around him and in the greater community supported people like Francisco and Francisco. So I'm gonna skip this example. I'm gonna touch on this one really quickly because I think it's really interesting how this has happened. So if you all are know of Global Labor Justice Committee, they're working on a campaign to support fishermen in the Taiwan area to get Wi-Fi on their boats to be able to communicate with their family members and also the union. I think this is just an extremely interesting case of how we can expand like what we demand at the workplace, right? These workers are demanding Wi-Fi on a boat in the high seas of Asia. And I'm just really impressed by that campaign demand from the workers themselves and their ability to, the organization to rally people across the country to support them in solidarity. And so here's a photo of us at the Boston Seafood Workers Expo, where we rallied a whole bunch of people to support the Taiwan, well, they're not Taiwanese, but the fish workers in the Taiwan seas. So I hope I brought you to the point in this story that when we identify one struggle in one site, right, one realm, whether that be the workplace or the community, we are able to accomplish so much more, and that is transformed in every realm of a worker in our community members' lives. And what's next? So at Jobs with Justice, we're really excited in the coming year to continue to build statewide and locally based organizing hubs where we build our coalitions together. We are focusing on capacity building to support our coalition members and movement partners to strengthen their own organizations and our movement. We're continuing to have leadership development opportunities to grow our leadership pipeline of workers and activists to organizers to future directors. And also after the shift that all of us had to go to Zoom and to online communication, really think about and delve deep into digital outreach and organizing to meet the future of work and the world at large, to get in front of stakeholders and to meet people where they're at. And so I think for us at Jobs with Justice and for many of our coalition partners and friends, right, we are going to, in the coming year, really look into how we digitally organize and outreach and then recruit and build our membership and our leadership so that we can have a strong and deep movement for the future. Thank you.
All right. Did that work? Great. Let's have another round of applause for our fantastic panel. So now we have some time for conversation, questions, discussion. And so what I think might make sense is we can see how much participation we have both online and in the room. Maybe rather than going one-to-one back and forth, we'll see if there's a couple comments and questions we can gather. And then I want to make sure at the end we have time for closing comments from anyone who wants to give any. And with that, the floor is open. And if you can introduce yourself, even if you spoke earlier.
Hi, Jennifer Shearer, Economic Policy Institute. I'm going to ask a quick one that maybe connects the first and last presentation together. Jim, I wanted to know if you're beginning to see or hear from folks about any initial impact of the CEMEX decision on organizing and behavior of employers, particularly in the process. I feel like I have maybe one very anecdotal example, but I'm super curious to hear what people are seeing on the ground. And then similarly, with workers that you're in touch with, Lily, are we seeing any, initial shifting of the terrain that workers feel like they're facing in organizing campaigns from that and the other NLRA changes? So.
I'm Jeanette Wixland from PERI again. So I had a question for Laura about the Fair Food Standards Council. Just a couple things. I was curious about how the council is supported, like how is it funded, because it sounds very labor intensive. And then also, if you could say a few words about the trajectory of its work in terms, I imagine it was really hard at the beginning, trying to get it established and effective. Can you say a little bit about, how it's gotten to where it is now, where it sounds like it is super effective?
So for this, we're going to use your handheld mic, and if you want to kick it off, and then we can just see whoever wants to.
Can you hear me? Yes? No?
Yes.
Okay. So I want to hear Jen's anecdote about CEMEX. Because at this point, we're talking late August is when this happened. It's not really been very long. What I've seen is, and what I've tried to follow, is the law firm advisories to their clients in which they're saying, hey, this is a big deal. You better take some serious steps. Don't think you can do business as usual because you will end up with a bargaining order before you know it. And so to the extent that, obviously every management side firm wants to make money, and so they're going to be raising neon signs, which subtext of which is hire me or give me more hours. But I think the fact that it's coming from several different places suggests that the employer community understands that this is serious business.
Yeah, thanks for the question. So at Jobs with Justice, we are working pretty closely with the Starbucks Workers United group in Massachusetts. And although there are conversations about CEMEX and how it'll affect the organizing, I think from afar, from observing, the issue is that the workers themselves don't really know yet how this decision will affect them or benefit them. So I know in the last panel we talked a lot about popular education, right? But thinking as the organizers of the Starbucks Workers United group themselves and also the union, and us as allies, how do we provide and bring people together in conversation about what's happening nationally and locally, and how we want to have listening sessions to show the workers that we as allies also support the work that they're going through and the also really difficult retaliation that they're facing at work.
Thank you. So thank you for those two good questions. I'm going to take them in reverse order, if you don't mind. So as far as the trajectory of the work goes, I actually took out the ultra nerdy slide from the presentation, which showed the compliance graph, and it was an incredibly steep curve for participating growers. They had a very big hill to climb in the first, I would say, almost 4 to 5 seasons. And then you see a really plateau at a very high level. And the kinds of things that, not that bad things don't continue to happen, but the kinds of bad things that happen have decreased in severity and frequency. And when we do have, I mean, I think it's important to note that we do have unprecedented access to workers. We've had like 100, and I'm really recently in response to something that Jim's class brought up, we tallied up 153,000 worker interviews, 24/7 complaint hotline, access in the fields, at housing, at the education session. So we do hear about a lot of things, and workers are now at the point of raising concerns about issues that are not even code issues, but they're things that can be helpful in their lives. I mean, we recovered incredible amounts of COVID payments for workers who would never have gotten them otherwise, for example, and a number of things like that. But I do want to emphasize that it was a very steep curve, and what was necessary, I didn't do much anecdote, but I will now. The very first week that our hotline went live, a worker mistakenly, our number is printed on their paycheck, but some of the growers also print their office numbers on the paycheck. And so he called the office number and gave his whole complaint about uncompensated wait time, which was a classic violation that was, it's a law that was never really enforced, certainly in Florida agriculture, and a few other things that he had to say about conditions in the fields. And so it was a relatively small farm, under 100 workers, and the grower himself was present and went out to the field, found the worker who was identified to him by the company hotline because there was zero confidentiality as far as they were concerned, and grabbed him, by the shirt, shook him, and fired him in front of the entire crew. And then he found our complaint line number. So you can imagine the first week, what we knew with a great deal of certainty is that if something wasn't done immediately and effectively, that complaint line would just stop ringing, because there'd be no reason if you couldn't protect a worker in a situation like that. So we did go out, we did the investigation in the same day, and it really wasn't highly problematic. There were a ton of witnesses to what had happened. And the very next day, long story short, the next day, the grower himself was out there apologizing in front of the entire workforce on time that he was paying them for, and with a coalition of Immokalee workers, representative present, with the Fair Food Standards Council present, and assuring workers that he was inviting this worker back to work and paying him twice what he had missed in the days before's earning, and anybody else who had a complaint should never hesitate to call the Fair Food Standards Council. Suffice it to say that we were able to resolve a lot of complaints out of that farm with no further problems. But, we had a devastating sexual assault cases in the beginning as well. But, it is labor intensive, but it is also a relatively small world in the world of farm labor contractors. And so even though now we are in multiple states, unfortunately, there are, dynasties of these contracting families and agencies, and the word gets around. I mean, people could not believe that supervisors were actually losing, contractors who are so valuable to the farmers because they recruit, they transport, they sometimes house, that they were losing their job, and dozens of them lost their jobs in the first wave of enforcement in the Fair Food program. So it definitely has gotten easier, and now I would say that the kinds of growers who are coming in two ways. So it is a different story. They're coming because they're being pushed in by participating buyers who want more of this in their supply chain, of this kind of risk prevention, so they could need quite a bit of cleanup. And there's also higher road growers who are coming who are saying, well, I'm doing everything I should be doing, and now I can get kind of gold standard recognition for it. So yes, long story short, the work has definitely changed. But there's new, as we go into new states, it's kind of can be deja vu all over again. And the other question about support, we have multiple means of support. One is the buyers make in the last contracts that CIW negotiated with participating buyers. They do make an annual support payment that goes strictly to the monitoring organization. There also is a national sustainer program, so like just like I'm sure all of us support like National Public Radio, you pay whatever you can pay monthly, and that went from nothing like one $10 contribution to now hundreds of thousands of dollars of people who want to do something to ensure that all their food will someday be fair food. We also get a large amount of funding from major institutional funders, foundations. And last but not least, we have a sponsor program for chains and food co-ops that can't move enough volume to actually be a participating buyer, but they would like to support the program. So they source Fair Food Program produce when they can, and they make an annual support payment. What we have not done to date, is to take money from the growers themselves. Two reasons there. One, the analysis that CIW had about that at the end of the day, growers and workers are really on the same side of the equation of that downward pressure from the top of the supply chain, the consolidated retail brands, and taking money from the growers was just another economic pressure that ultimately is going to result, in some way or form a negative impact on workers. And of course, my former judge's heart is very happy about not taking money from the people that we are monitoring, and we don't have a vested interest in whether they stay or go, besides us wanting them to be covered if they are in compliance.
Great. So we can take another round of questions. And again, please introduce yourself briefly.
My name is Wen Jue. I'm working for Verite as a local NGO working on corporate social responsibility. My question is for James. I'm curious, as a committee of experts for the ILO, what is your opinion on the fair food program approach to labor, to the interest, to protection of the interests of workers, and workers' rights to freedom of association and collective bargaining. We know that I had a short conversation with Greg in the morning. He thinks this two approach are complementary with each other, but there is also opinion that the alternative approach, other than workers' rights to FOA and collective bargaining, could be used by employers as a way to impede workers' rights to FOA. The other approach, right? Like a different approach to FOA. Is it clear? Sorry. Is my question clear?
The last part wasn't so clear. Right, I just want to make sure I understand the question.
Yeah. Okay, I just want to hear your opinions. Yeah. Okay, that's fine. I just want to hear your opinions on the relationship with different approaches to protection of workers' interests. Okay.
Hi, my name is Kristen Straley. I'm an organizer at Massachusetts Jobs with Justice. And my question is for Laura and for Claudia. I'm wondering, especially Laura, because you said that the program is expanding rapidly and also internationally. And I'd love to know a little bit about how or whether the language and workers are also contributing to the Farm Bill that's coming up. And I wonder if there's more pressure to get kind of this fair food program into the larger bill, that this is this like a priority really with that bill? And my guess is like no, but I would love to hear your thoughts on how or whether any of this language is getting interwoven with other Farm Bill issues. And Claudia, since you have like such a local Massachusetts expertise, I would love to know too if that is in our community, if any of that conversation is coming up, especially since it's worker led. Thanks so much.
Can you hear me? Yes? Okay. So thank you for that question. I think the answer is complicated, as you might expect. I think that when one thinks about the challenges to freedom of association transnationally or globally, first of all, freedom of association is almost a sine qua non of lots of other efforts for workers to be able to speak out forcefully and make a difference. And they can't do that when the government regime is so repressive that, as Thea described, they're being murdered in their beds before they can do what they have a right to do and what their government, in theory, recognizes their right to do because it's part of the fundamental declaration. So in that sense, the question is, where are the other actors who might make a difference, at least transitionally, if not permanently? And part of the answer is multinational enterprises. I mean, to the extent that they are in a position, sometimes, I mean, this is, now I'm talking to you now as someone who's been on the committee for 13 years but is not expressing the official committee position. I want to be absolutely clear about that. But sometimes you have to recognize that it's the corporate actors who have more power and more influence and more ability to shape the potential for workers to get some of those rights. And I think that you see that in the statutes that are being passed by European Union countries to create, if you will, process-oriented protections. I mean, one might call it mandatory corporate social responsibility in the sense that there are penalties if you don't do it right. The problem is, and the challenge is, that a lot of that is very process-oriented, and the danger and the risk of a process-oriented solution is that it becomes a little bit of a safe harbor, and that if you can jump through the hoops of having a complaint mechanism in place and having, then the fact that there's still sexual violence or forced labor going on in your supply chain, you're in a position to say to the German government or the French government, well, we've done all the things you asked us to do. And that's challenging. So, I mean, I think that's where the more pressure that an organization like the Coalition or the Fair Food, I mean, this kind of model is driving results, substantive results, in addition to process results. And I think you have to have both in order to have a chance to generate the kind of protection for freedom of association that sadly is not immediately available in a lot of government settings.
I know you didn't ask me, but I am going to take the liberty anyway, just because some clarification from the ground level of enforcement, which is where I live. We are now present, and it has to do with expansion as well. We are now present in a couple of states where the right to unionize and to collectively bargain exists. So the role of the Fair Food program in those cases will be exactly what it is, to enforce every other legally existing right. So we have already modified our education materials to inform workers on farms of these new rights and to tell them that we can do what, what is critical. I know from my youth as a union organizer that one of the things that is critical is to protect organizers from retaliation. There's nothing that stops an organizing drive faster than having all your leadership fired. Well, just like that story I told a minute ago, you can have a union organizer reinstated overnight in the Fair Food program. And it is much more difficult if you have to process an unfair labor practice, and go to hearing, as I did many times as a younger person. So that is one thing that is happening. And the other thing that's happening which I would reference you to Thea Lee's presentation and talking about the Bangladesh Accord and Lesotho, the gender justice agreements. In those worker-driven social responsibility programs or enforceable brand agreements, the signatories are both human rights organizations and unions. So unions were in place in Bangladesh and in Pakistan, and yet they had not been able to resolve certain issues, and in Lesotho as well, certain issues of factory safety. Factories were collapsing, people were burning alive in factories, or in Lesotho, women were being raped on the factory floor. And unions saw the potential to wield this market power through these kinds of agreements and solve those intractable problems. So that is just from the front lines about compatibility. So I think, was somebody else supposed to, oh, what were you, me? Oh, me, okay. The Farm Bill. No. The holy grail for in terms of government involvement, has always been for us a procurement, and preference for growers who are doing the right thing and respecting workers' rights. As Greg mentioned earlier, the USDA has recognized growers who are either participating in a collective bargaining agreement with a union or have a worker-driven social responsibility program in effect as being eligible for what they call the platinum standard of economic incentives under the new H-2A visa program. And there are a couple of jurisdictions that are not public yet, but a couple of jurisdictions that are placing in their specifications for procurement contracts, fair food programs preference. But in something national like the Farm Bill, I don't think we're definitely not seeing it this time around.
We're filibustering here. I just wanted to say something about procurement that went back to the first question, if I could. I'm sorry to be filibustering like this. But I think one of the things that is hopeful about some of the European statutes, and I think of the German one in particular, is that it's not that they necessarily give you an edge up if you have met certain standards, but if you haven't met them, then procurement, the penalty is you can't participate in procurement of government contracts. And in Germany, that's a big deal. And not every statute has done that, but to the extent that they are doing it, it's a very useful model for both other emerging global efforts and possibly some domestic ones.
I would say that on the local level, we have had conversations in our campaign about some of this, like growers doing the right thing, the campaign of, remind me again what it's called?
Fair food program.
Yes, the fair food program, or like just movement in general. I do want to note that we have a lot of farmers in our region who do the right thing. Like, we have good farmers. Our position is really that the state has to fix what's wrong with our laws. And it's not, and I agree that like farmers and farm workers are both on the same side of the equation. Because we have many farmers that pay a good wage, that some who even pay overtime, some who are engaged in sustainable agriculture. So we have a good movement here. It's part of our conversation. It's part of how do we leverage some of that into some of the work that we're doing, so that we can say this food that you're buying is coming from fair food farmers. Farmers who are cognizant of the way that they treat their workers. We've been in conversation with a lot of, no offense to anybody, but like we've been in conversation with a lot of younger farmers who are thinking about the ways that they can promote equity for the labor force on their farms. And so there is a movement there, and we are thinking about how to incorporate it. The other thing is, we have tried to organize. Well, we have not, but farm workers have tried to organize in Massachusetts, and it's fairly simple in Mass. There's card check. It's a lot easier than maybe in other states, but there have been efforts to organize farm workers in Massachusetts. And I think to the extent that we can kind of have parallel roads to try to move that, we would have more leverage in that regard. But yeah, we're kind of at the beginning of our campaign, so definitely part of that conversation includes the fair food. And maybe you guys will come to Massachusetts and make it better.
Awesome.
Definitely a target state. So we're going to take one question from online, and then we have time for maybe one other brief question from the audience, and then I want to give everybody a final word.
Thank you all. For Judge Laura, can you talk about how the FFSC has been working to adapt to its new context in Chile and South Africa?
Anybody
Thank you.
else?
Oh.
I hope this is just maybe a related extension, but wondering if you can add a little more about the process of expansion into new states and what that looks like and who you work with. And that's
Great. So if you want to start out, and then if anybody else wants to give just a few closing remarks on takeaways we should have from this session today. Thanks.
Yes. So in some ways, the expansion to Chile and South Africa, while certainly sounding more dramatic than going to a new state, it is similar. So we see, first of all, the way expansion happens is that there are possibilities through the supply chain of either existing or new participating buyers. Because unlike the voluntary certifications, we don't just go if there's a friendly farmer, for example, and we don't have a mechanism for market enforcement. We don't go. We either try to bring them into an existing participating buyer supply chain, or have an existing buyer reach out to them in some way. But that is the first precondition for the supply chain dynamic needs to be there, and it was there for us in the expansion countries, and it is. So that is the first thing. The next thing that happens is we talk to groups on the ground, everyone that we can find, or everyone who will talk to us about what is going on with workers, the situation of workers' human rights and labor rights, and who is active in that endeavor, and what do they believe the workers' main concerns have been from their experience, and when the ideal and what we're doing right now in the process of doing in Chile is focus groups with workers themselves who are in the industry in which we are going to be expanding, because they are the experts in how their rights are being violated, if they are, and and how to best eliminate that abuse. And that is how the code adaptations will be done. In addition to, like I said, we're now present in Colorado. We have a small, very small presence so far, but promising to grow in California. And so obviously the law of the jurisdiction is the baseline, and the law is different. And in Chile, for example, the government is, to say they are excited is, I don't know, I'm not sure. There's got to be a new word, because I have not, in my lifetime, and I would venture to say I'm probably the oldest person in this room, but in my lifetime, I have not experienced that kind of embrace, by government anywhere. They have named the Fair Food Program as a strategic ally in their fight to combat forced labor, child labor, and sexual violence, and we are strategic advisors to their interministerial commission on those same subjects. The Minister of Agriculture has publicly stated that he thinks this is something that growers and buyers in his country should embrace. So it is, we do outreach to government when that door can be open, but the most important piece for us is to know what workers' concerns are, and how the code should be modified. And that is also treated with a reality check from the growers who are going to be entering the program to see how the rights that are being drafted can be best implemented in their operations, because each and every one of them in the new protocols that we have forged in the U.S. has been run through the test drive of, well, how, not to give any ground on the right itself, but on the how is field truck safety going to be implemented on your farm? Where should the emergency stations be required to be for heat stress relief, or practical things? The same process will have to happen there.
Great. So why don't we go the same order that we had the presentations? We have just a couple short minutes, but just any brief closing statements.
First of all, thank you for the questions. And I think what I would say is that I don't think there's a sense in this room, but I would hope that we can avoid a false dichotomy between contract-based efforts to protect freedom of association and improve standards, and law-based efforts to do it. They can be mutually reinforcing. There are going to be moments when one of them is clearly more effective than the other. But I'm still thinking about Marley's pendulum quote from last night. I'll always think about it. But yes, the pendulum swings, but it's possible that we have 5 more years ahead of us to get things done. I see Thea sort of sighing in hope, praying, and we have to be prepared to seize that at both national and global levels, and obviously state and local levels.
No. Go ahead. I mean, I can. Sorry. No, it's okay.
Right now we are in a time where workers are activated, and workers want to see change for themselves and change for the generations to come before them. So as I would term myself as a movement lawyer, as somebody who's working on the ground, but also like up here, trying to help create these changes, I think leveraging the power of workers is really important and helping them mobilize. And so that's what we're doing with the Fairness for Farm Workers Coalition, trying to incorporate the worker voice, trying to empower the workers, whether it's through collective organizing, whether it's through sharing their stories, and telling us, like, yes, we have good employers, or no, there are things that we still need to fix. Inviting people who are directly benefiting from the food that we all eat, to support the efforts, because all of us can do something about this. And I guess sort of like my call to action would be, think about wherever you live, how you can participate in the food chain supply, because you eat it. And so whether it's calling a legislator, whether it's bringing awareness to the issue, whether it's just donating even to the efforts that are before you, I think that's going to help move the needle along a little bit. So thank you for having us and for letting us chat a little bit about the work we're doing, because the more people know, the more we can make this happen.
Cool, yeah. Thank you to everyone who spoke with me on the panel, and I've learned a lot today. And I think right now we're in this portal, and we're looking we're looking back in the last couple of years and the last couple of decades, and we're looking forward. And it's up to all of us to work together and envision this new future where we can advance so much more and build more worker power, and I'm looking forward to it.
Yeah, no, it's hard to add anything much more to what my co-panelists have said and to all the wonderful things that people have said in their presentations and comments. I would just say that, there was, there's so much work to be done, folks. There's always been so much work to be done. And so and we're hearing about so much good work being done in so many places and by different organizations. Let's not forget who the enemy is, and let's not forget how quickly workers' efforts can be squashed. And there was a slogan that was very popular when I was young, which was, by any means necessary. And in different environments, different methods and different tools and different approaches work. I used to be fond of, in these conferences that I would be at, particularly convened by funders, to ask, well, how many people here work in the rural South? And you'd see 3 or 4 hands go up. But you'd have, out of a room of hundreds. But so you would have, you must bring the lens of reality to the situations in which you are working. And let's keep the goal in mind, which is to advance workers' human rights, to make sure that, and coming from the farm worker place, that all food is fair food, even if it's not the Fair Food Program or if it's something else, and to see that workers have a dignified existence in their workplace. And so that's what I can say, and thanks to everyone for your each and individual efforts to make those goals happen.
Great. Why don't we all give them a final round of applause?